Hello, and welcome to another episode in the Georgia Workers' Compensation video series. My name is Jason Perkins. I'm an attorney who specializes in handling Georgia workers' compensation cases. I created this series of videos to provide people who've been hurt at work in Georgia with helpful information about Georgia's workers' compensation laws and the benefits they should receive under those laws. Now, let's jump straight into today's topic. Today, I'd like to talk about, does a drug test prevent you from getting Georgia workers' compensation benefits? Well, that can be a difficult question to answer. A positive drug test can prevent you from getting Georgia workers' compensation benefits after an injury in the job, but it really depends on a number of different factors. Now, first, let's talk about why your employer and the workers' compensation insurance company sent you to get drug tested after you got hurt at work. This happens in most Georgia workers' compensation claims. The employer or insurance company sends someone to get drug tested after they've had an injury on the job. And the reason this happens is that Georgia workers' compensation law has drug test rules that can result in the denial of your claim even if you get hurt at work. These rules provide a presumption to the employer that your injury was not work-related if you get a positive drug test that meets certain factors. Now, the factors are very specific as far as what your employer has to meet. But if you test positive, meet these factors, the presumption that your employer gets means that they're probably going to be able to deny your case. Also, there's a part of Georgia's workers' compensation law that says that your refusal to take a drug test can also result in this same presumption. So, will the workers' compensation insurance company deny your case if you have a positive drug test or you refuse to take a drug test? Well, probably, assuming that they meet the requirements of the law. As I mentioned earlier, there's specific requirements as to what type of testing your employer has to do. So what types of standards the drug testing has to meet, as well as when it must show that you were under the influence of drugs. So there's a certain timing as to when the testing probably needs to take place. But assuming that the insurance company thinks that they have met these standards, they're probably going to deny your workers' compensation claim because of this presumption under Georgia workers' compensation law. This denial is legally referred to as a controvert. You'll usually receive a document in the mail from the insurance company or maybe by email that will be either a Form WC-1 or a WC-3 that says that your claim is being denied. Normally they'll indicate that it's being denied based on willful misconduct, which is the section of Georgia workers' compensation law that the positive drug testing falls under. Now, does this denial mean that you cannot succeed and receive workers' compensation benefits? In other words, is it the final straw? No, not necessarily. The insurance company's denial just means that they're not going to voluntarily pay you workers' compensation benefits in your case. If you disagree with that denial, you can still request a hearing in your workers' compensation case, and a judge ultimately makes a decision about whether your injury is covered under Georgia workers' compensation law or whether it was caused by willful misconduct. At a hearing in front of a Georgia workers' compensation judge, you may be able to present evidence that the insurance company did not meet the legal requirements to get the presumption of a positive drug test. The insurance company often relies on this presumption to prove their case. If the drug testing didn't meet the standards and the insurance company does not get this presumption, it's going to be much harder for them to prove that your injury was caused by willful misconduct. Now, even if the drug testing was done properly and the insurance company gets the presumption, that is not necessarily the end of the case. You may be able to present evidence still that your injury was not caused by willful misconduct. Sometimes you can present other evidence that shows that even though you tested positive, that you were not intoxicated or under the influence of drugs at the time of your injury. Some positive drug tests may show up for a while after the drug no longer is having an effect on you. So There are times where other evidence can be presented to demonstrate this, and you can potentially overcome the legal presumption that the insurance company gets. A third approach can be to show that even if you were under the influence of drugs or alcohol at the time of your injury, that you being under the influence of those had nothing to do with your injury. A classic example of this might be if you were riding in a car as a passenger and on the job, driven by another co-employee, and another car just rear-ended you. Now, you being under the influence of drugs in this scenario may have nothing to do with the fact you were injured, because there probably was nothing you could do to avoid that situation, even if you weren't under the influence of drugs or alcohol at that time. The rules about what drug testing creates a legal presumption that your injury is caused by willful misconduct and overcoming positive drug tests are very complicated. Often, if you're looking to fight a positive drug test or a willful misconduct denial, a Georgia workers' compensation attorney can be helpful to you in doing that. I hope you found the information in this video helpful. If you have, please consider 2 things before you go. First, I'd really appreciate if you give this video a like or a thumbs up, and consider subscribing to this channel if you'd like to be notified of future videos in the Georgia Workers' Compensation video series. Second, if you've got workers' compensation questions, please reach out to get answers. I offer free consultations in Georgia workers' compensation cases. If you'd like to set one of those up, there's 2 easy ways you can do so. The first is by calling the phone number at the bottom of the screen, and the other is by reaching out to us to our website, which is www.perkinslawtalk.com. Just click on and submit the free consultation request form there, and a member of our team will reach out to you and get a consultation scheduled. I'd like to thank you again for watching this video today. I'd like to wish you the best of luck as you recover from your injuries.